Imagine you're scrolling through social media and you see a post calling you a total scam artist. Ouch. That's rough, but can you sue that person? In today's video, we'll explore when statements of opinion can lead to legal action and when they're protected speech. Hi, I'm Minc, attorney and founder of Minc Law, the nation's leading law firm when it comes to dealing with online defamation. Understanding the difference between statements of fact and opinion is crucial in defamation cases. Usually, opinions serve as a complete defense in defamation claims. However, there are situations when that's not always the case. Keep watching to learn the difference between statements of opinion versus statements of fact and when statements are actionable as defamation. Defamation can be broken down into two types: libel and slander. Libel refers to written or published statements that harm a person's reputation. Slander refers to spoken words. Both types can be damaging to an individual or business, but proving either can be challenging, especially when opinions are involved. Typically, to prove defamation, a plaintiff must establish four elements: a false statement of fact, published to a third party, causing injury to reputation, and with some degree of fault, either negligence or actual malice. But what happens if the statement in question is an opinion? Let's find out. Opinions are generally a complete defense to defamation claims because they are not considered statements of fact. The line between fact and opinion can sometimes be blurry, and opinions can sometimes still be legally actionable as defamation. Typically, courts consider several key factors in determining if a statement is an opinion, including its context, tone, verifiability, the average reader test, and by analyzing the specific language in the statement. Let's review each of these in turn. Context is the setting in which the statement was made. If the statement was made as part of a debate or other commentary, it's more likely to be considered an opinion. For example, an opinion expressed in an op-ed or other column or blog post may be perceived differently than a statement in a news article or a press release. The overall tone of the statement is another essential factor. A statement that uses hyperbolic language or humor might indicate that it's an opinion rather than a fact. For instance, a satirical piece or a comedic roast where statements are grossly exaggerated are clearly not meant to be taken literally, in our opinion. Verifiability is also an important consideration. If a statement can be objectively proven true or false, it's more likely to be considered a fact rather than opinion. However, if the statement is based on personal feelings or subjective experiences, it's more likely to be classified as an opinion. For example, claiming that a restaurant's food is disgusting is a subjective assessment based on personal taste, making it an opinion. Courts will also consider how a reasonable person would interpret the statement. It's called the reasonable reader test. Would an average reader or listener perceive the statement as fact or opinion? If it's likely that most people would see it as an expression of personal belief, then it's probably an opinion. Finally, courts also examine the individual words used in the statement. Phrases such as, "I believe," "I think," or "in my opinion" can indicate that a statement is an opinion. However, using these phrases doesn't guarantee that something will be considered an opinion automatically, especially if the statement still implies undisclosed defamatory facts. Although opinions are typically protected speech, in most cases, there are situations when you can still sue or be sued over an opinion if it implies an undisclosed false assertion of fact. For example, stating, "I think John's a thief," could be considered a fact or an opinion. If someone dislikes John and says this when talking about their general dislike for him, then the statement is clearly an opinion. If this was said during a conversation about actual criminal theft, then it could be seen as implying actual knowledge that John committed theft, even though the statement is phrased as an opinion. As another example, if someone left a 1-star Google review for a restaurant that said it was disgusting and unsanitary, depending on the context, this could be a fact or opinion. If the reviewer was simply talking about his or her dislike of the food without anything more, then it's clearly an opinion. However, if the reviewer made the statement in the context of talking about how the restaurant allegedly has a cockroach infestation, this could be considered defamatory and legally actionable. While opinions can sometimes serve as a defense in defamation cases, it's essential to remember that opinions implying an undisclosed defamatory fact may be subject to legal action. If you have any questions, leave a comment below or visit minclaw.com, where we have an entire resource center full of free information and advice on the subject. And if you believe you have a valid defamation claim, don't hesitate to contact us to schedule an initial consultation today. I'm Aaron Minc. Thanks for watching, and I'll see you in the next video.